Hi everyone, I once again welcome you to our page, Know the Law. My name is Joel Ivan and I'm going to take us through judicial review in Uganda. Before I proceed, however, I would like to echo on something I mentioned something back that our page or platform or discussions at Know the Law do not intend in any way to contradict, vary with, or from what your lecturers have taught you, but rather to supplement on the same because we understand some of you are fast learners and you pick from class, but still amongst you are friends who need this guidance. So our aim is to make sure that the law is understood by everyone, right? That the law is made easy to each one of us. However, in due course of executing that aim, we do not intend to spoon feed you. What do I mean? These videos are not conclusive enough. Therefore, you are required to do further reading upon each topic we discuss here, because the law is all about reading, right? So judicial review in Uganda, I believe all of us did administrative authorities, where we looked at establishments of given public organs with quasi-judicial functions, such as the Judicial Service Commission, among others. So administrative authorities or administrative law one sought to know the establishment and existence of such organs, right? But administrative authorities, I mean administrative processes or administrative law too, seeks to prescribe various ways through which those organs must exercise their judicial functions, must exercise or execute their functions, right? So, judicial review, simply put, is the process through which the High Court exercises its supervisory powers over the decisions and proceedings of those organs with judicial functions. Yes, we are going to be guided by the Constitution of the Republic of Uganda, the Judicature Act, Cap 13 as amended, the Judicature Judicial Review Rules as amended, and the case law. Yes, so um, Article 42 of the Constitution tells us that any person appearing before any administrative authority or organ has a right to be treated fairly and justly, and that person shall have a right to apply to courts of competent jurisdiction or to courts of law uh, 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 in regards to any decision or administrative decision reached against him or her, right? So the Constitution is telling us that every person has a right to be treated justly and fairly, and in due course of any proceedings against you, and you find or you sense any kind of violation of your right to be treated justly and fairly, then you have a right to apply to court of law for judicial review, right? So, within what time or within what period of time should you apply for judicial review? Rule 5, sub rule 1 of the Judicature Judicial Review rules tells us that you have 3 months within which you must apply for judicial review. However, I should also note that that time can be extended. It shall be at the discretion of court to have that time extended. That shall be upon your application for extension of time. So, what mode of application? Sorry, what yeah? So, what mode will you apply to court for judicial review? Rule 6 sub rule 1 tells us that the mode shall be by way of notice of motion. I believe most of you have not done civil procedure. Under civil procedure, you look at 5 ways through which we commence civil proceedings, and one of them is by way of notice of motion. So, Rule 6 tells you that the mode of application shall be by way of notice of motion. So, Rule 7 also tells us that courts have 90 days within which they must deal with your judicial review application, right? So that is it. Let's look at the grounds for judicial review. I'll give you various cases, but for now I'm going to give you one. But at the end of this session, I'm going to give you various cases that you have to read, just like I told you that we do not intend to spoon feed you. Anyways, let's look at the case of Agrebue versus Attorney General. Yes, they gave us 3 grounds which we must prove for judicial review. One of them is illegality, we have irrationality, and procedural impropriety. So what about illegality? Illegality, most scholars or most people explain illegality under the doctrine of ultra vires. So what is ultra vires? Ultra vires means acting beyond your powers. You have given powers, but you act beyond them. You go beyond them. So by so doing, you will have acted illegally. For instance, you're the chairperson. You're the chairperson of the disciplinary committee at a given school, and your powers are to suspend any student who has violated the school's rules and regulations, but in due course you just have those people expelled. So that expulsion will amount to ultra vires because you will have exceeded your limitation, which were suspending, but you went on to expel, right? So that's illegality. So irrationality, what about irrationality? Irrationality means acting outrageously, that no sane person would reach that decision that you reached if at all they were in your shoes. For instance, uh, yes. For instance, you let me use the same example that I've used. You're the chairperson of the disciplinary committee, but the rules are telling you that in case you find this student, in case a student violates school rules and regulations, just have them suspended. But you go on before even you hear them out. You go and have them first of all caned, then secondly may done every sort of bad thing against them. Then you have them fired or expelled from school. That amounts to irrationality because you will have acted outrageously. That no sane person would do that because the law requires that every person be treated justly and fairly. Are we together? So that's irrationality. Um, let's look at let's look at procedural impropriety. This is when the rules and principles of natural justice have not been complied with. What are the rules of natural justice? I know you're going to have a topic, an independent topic on principles of natural justice. We have various principles under natural justice. For instance, any person appearing before any administrative authority or tribunal has a right to be fairly heard. So, what amounts to fair hearing? Legal representation, no bias, adjournments, the language, use of a language understood by that person, among others. So we have to make sure that the principles of natural justice are complied with. So failure to comply with the principles of natural justice amounts to an illegality, and therefore the person the person affected with your decision has a right to apply to court for judicial review. And upon a successful application to court for judicial review, Section 36 of the Judicial Act tells us that courts can grant any of the following orders. One of them is certiorari, mandamus, and prohibition. What is certiorari? Certiorari means removing any proceedings or matter to the High Court. So this is, certiorari means quashing the decision. So if at all they expelled you, so court may be like, no, but you didn't have to expel this such a person before being heard, right? So let's quash that decision of expelling him from school, right? So that's certiorari. So what about mandamus? Mandamus is that's section 36(1)(a). Mandamus requires any act to be done. Yes, court compels you to do a given act. For instance, before expelling this student, first hear them out, right? First give them a fair hearing. That's mandamus. Then prohibition, prohibiting any proceedings or matter. Then prohibition simply means that you're prohibiting you're prohibiting or stopping the that organ or authority from acting illegally. You're stopping them, you're stopping them from further further performance of illegalities. So that is judicial review for us. So let's look at given cases that you ought to read for judicial review in order to understand it very well. Read the case of the Editors Guild, Uganda Limited, and another versus Attorney General. You're going to read the case of Kuluo, Joseph Andrew, and others versus is it Attorney General as well? You're going to also read the case of Yasin Sentumbu and another versus UCU. I know now UCU students are happy. Anyways, we are going to also read the case of Agwewire in depth. Actually, Agwewire was yes, that case was appealed 2 times, Court of Appeal and Supreme Court. Yeah, you read that those cases, they will help you a lot. You will also read the case of Uganda Law Society versus Kampala City Council Authority and another, right? All right, thank you very much. For any questions, kindly feel free to ask, like, share, and comment.